Bentornati e buonasera ai nostri ascoltatori di London One, questa sera con un'altra puntata di servizio pubblico e parleremo di una tematica che è ancora legata a problemi che riguardano l'European Settlement Scheme. Questa volta lo facciamo insieme a Ray Davis, che è il General Counsel di Independent Monitoring Authority, che proprio recentemente, parliamo di pochi mesi fa, a novembre, hanno deciso di portare in tribunale l'Home Office e adesso scopriremo il motivo per cui è stata fatta tutta questa situazione. So welcome, Ray Davis, and thank you very much for being with us on London One Radio. Can you please explain to us what happened in November, why the Independent Monitoring Authority decided to bring this time the Home Office at the High Court?
Yes, of course. So the challenge that we brought before the court ultimately rests on the rights of those who hold pre-settled status under the EU settlement scheme. So those people are afforded a temporary right of residence in the UK. And the upshot of that is after 5 years from the grant of their pre-settled status, under the scheme, their right to live in the UK will come to an end unless they apply for settled status, which is a form of permanent residence in the UK. Now, so the key thing for us was that the fact that you might fail to make an application would mean a loss of your rights. And we felt that the withdrawal agreement agreed between the UK and the EU, set out quite clearly some limited circumstances in which those rights can be lost, and the failure to make a second application was not one of them. So we brought the claim before the High Court, and the judgment was handed down in December last year, and the court agreed with the IMA that indeed that element of the EU settlement scheme is unlawful, and therefore that requirement to make that second application cannot continue.
So basically, there is a lot of fear still of people who maybe they want to upgrade to the settled status, but they can lose their right of residence. And why they can basically fail in reapply for a settled status? What are the causes?
There are conditions around absences. So holders of pre-settled status, they can only be absent from the UK for some limited periods. So that is generally up to a period of 6 months every year. But also that there is the possibility of being outside the UK for up to 12 months on one occasion for an important reason. And those important reasons can be as a result of illness, pregnancy, giving birth, or are also national service. So on reapplication for settled status, then that is one thing to be aware of. But however, obviously with this case, with this claim before the High Court, what we were asking the court to consider is whether there is a need to upgrade, and therefore that's the question that was before the court, whether they need to make that second application. The court held that they don't.
Right. So what you are asking to the High Court, if it's possible, for example, in the future, that who is entitled of pre-settled status and stays in the UK, they don't need to do the upgrade. They can avoid it.
So the key thing for us was that if they fail to make any application, then they don't lose their rights, because from August 2023, some of the first holders of pre-settled status will start seeing their pre-settled status expire, and therefore they would no longer be entitled to stay in the UK. And what we say is that there is no need to make that second application in order to remain in the UK. But I think the one key thing to kind of point out to your listeners is the fact that the proceedings haven't finished yet. So there is an appeal, and therefore until that appeal is concluded, we would still urge everyone who holds pre-settled status to make their application for settled status as and when they become eligible. So if you've been in the UK for more than 5 years and you meet all the other conditions, then we would urge you to make that application.
But, did you understand why the Home Office decided to make this kind of regulation? Because if the withdrawal agreement doesn't say that if you fail to upgrade, you don't lose your right of residence. Why the Home Office introduced these regulations?
Good question. I'm not sure whether I can give a full answer to that, really, because I don't know what considerations that the Home Office took into account when they designed this scheme. I would say, obviously, that the withdrawal agreement is a new agreement. I know that it's based on many aspects of EU law, but it is new. There are areas of it which are quite complex, but I can't really say what was behind the design really from Home Office, because I wasn't there at the time.
And there was nobody from the European Union who basically said anything about this issue after all these claims that came out throughout these years and months.
So the European Commission did take part in the legal proceedings in support of the IMA. So they also put arguments before the court to support the position that the IMA had taken. And I know that in advance of that they had raised concerns around this issue, but obviously there were many aspects to the withdrawal agreement, and in fact part 2 that were considered at the time.
The thing that we need to say now to our listeners as well, as you mentioned before, that the case is not finished yet. So do you know the time when we're going to have like a response?
That's the question, and I'd love to be able to give you an answer. We are looking to try and expedite things as quickly as we can, but it will be months. I can't give a firm kind of steer on when exactly, but what we will make sure that we do is that we will be updating our website and all our social media channels. So keep an eye on our Twitter page, our Facebook page, and we'll make sure that is updated as soon as we have any updates.
Of course. What are the other projects that the IMA is now carrying on in order to preserve the rights of European citizens in the UK?
So we have a range of matters that we're investigating at this time, and we do actually have an issues log on our website which sets out all those matters that we're investigating. We are also conducting an inquiry at the moment, and that inquiry is also relates to the EU settlement scheme, and it's to do with the delay that people might experience when they first make their application. So when you first make your application to the EU settlement scheme, you are entitled to be issued immediately with a certificate of application. And what that certificate of application gives you, so it's a proof that you made your application essentially, what that gives you is all the rights that are contained in the withdrawal agreement, so the right to live here, to work here, to rent, to buy a house, etc. They give you all those rights whilst your application is pending. So whilst the Home Office is considering your application, you still enjoy the full range of rights. But you only can have those rights if you've got your certificate of application. And what we were finding was that it was taking a long time on some occasions.
If you have any problem related to European settlement scheme, please, you can also mention your problem to the independent monitoring authority, isn't it, on your website?
Yeah, so we have an online portal that people can report their complaints online. So if you find that you are not being able to enjoy your rights, whether that's to do your certificate of application or anything else, then please do report it to us, and that will be really helpful to us so that we can look into it a bit further. But at the same time, we would also encourage you to go through other channels to try and get your problem solved. So whether that is making a complaint to whoever is that isn't giving your rights, or writing to your MP, or whatever that might be, please do so, and we can look into it.
Thank you very much, Mr. Davies, for accepting our invitation for our show. And of course, as soon as we have more information regarding this case at the High Court for the pre-settled status, and we will call you back. We will call you back, and you will update our audience about this important issue. Thank you very much.
Thank you. Yes, more than happy to come back.